Welcome to SLP Nerdcast, the #1 professional resource for evidence-based practice in speech-language pathology. I'm Kate Granbois.
And I'm Amy Wonka. We are both speech-language pathologists working in the field and co-founders of SLP Nerdcast.
Each episode of this podcast is a course offered for ASHA CEUs. Our podcast audio courses are here to help you level up your knowledge and earn those professional development hours that you need. This course, plus the corresponding short post-test, is equal to 1 certificate of attendance. To earn CEUs today and take the post-test after this session, follow the link provided in the show notes or head to slpnerdcast.com.
Before we get started, one quick disclaimer. Our courses are not meant to replace clinical advice. We do not endorse products, procedures, or other services mentioned by our guests unless otherwise specified.
We hope you enjoy the course.
Are you an SLP or related professional? The SLP Nerdcast Unlimited subscription gives members access to over 100 courses offered for ASHA CEUs and certificates of attendance. With SLP Nerdcast membership, you can earn unlimited CEUs all year at any time. SLP Nerdcast courses are unique, evidence-based, with a focus on information that is useful. When you join SLP Nerdcast as a member, you'll have access to the best online platform for continuing education in speech and language pathology. Join as a member today and save 10% using code NERDCASTER10. The link for membership is in the show notes.
Hello, everyone. Welcome to SLP Nerdcast. I am without my amazing co-host, Amy Wonka, today, but I am not alone. I am here to welcome Danielle Green to the podcast. Welcome, Danielle.
Hi, thanks so much for having me.
I love talking with you. We have been chatting in this Zoom room for a half an hour before we hit the recording button. So I'm very excited to share your wealth of knowledge with the rest of our audience. You are here today to discuss special education law and how it relates to speech language pathology. You've done a webinar for us before, which I'll mention in a minute. But before we get started, can you tell us a little bit about yourself?
Sure. So again, my name is Danielle Green. I'm a special education lawyer. I got into my practice, as many of our special education lawyers do because of personal experience. And I work with families and their children to help them get special education services in the public schools. I do everything from 3-year-olds all the way up to students who are turning 22. I also work with families that are having discipline challenges in schools. And so the practice really runs the gamut. But again, got started because, my son needed services, and I was sitting in that IEP meeting. Actually, it was the pre-IEP meeting before I even got to the IEP table. And I literally felt like I was on like candid camera because obviously my son was having challenges, and, it didn't feel like we were like getting anywhere. Like no one wanted to say it, and so I was like, I went home that night and I was like, something has to give here. I must not be using the right words. And kind of my practice started from there.
I've learned so much from working with you over the last year and a half. And every time I talk to you, I walk away with so many nuggets of wisdom, and I'm really, really excited to share it with everybody. And I want to take a quick minute to just talk about some of the work that you have done. So you did a webinar with us about special education law about a year ago. It's available on our platform for our members. If anyone out there hasn't seen it, I highly recommend it. I learned so much from you. I will I'll put a link in our show notes. And I also want to give a special shout out to one of our listeners and members, Kate Andress. So Kate took your webinar and wrote in with all of these questions. How do I apply this? What do I do in this situation? And
Right.
Kate is a really big reason for why we decided to publish this follow-up episode. So just a quick shout out, a big thanks to Kate Andress for helping us create this episode and draft all of these follow-up questions for you. Again, anyone who's interested, I will link the original webinar in the show notes. Before we launch into some of this information, I'm going to quickly read our learning objectives and our financial and non-financial disclosures. Learning objective number 1, Identify at least one of the purposes stated in the Individuals with Disabilities Education Act, or IDEA. Learning objective number 2, describe the difference between an IEP and a 504. Learning objective number 3, list at least 2 legal considerations for recommendations of service delivery. And learning objective number 4, list 2 strategies for advocating within a school setting when administration is not supporting compliance with an IEP. Disclosures. Danielle's financial disclosures. Danielle is the owner of Exceptional Children Special Education Advocacy, LLC. Danielle's non-financial disclosures. Danielle is a member of the Massachusetts Bar Association, Council of Parents, Attorneys, and Advocates, or COPAA, and the Special Needs Advocacy Network, Inc. Kate, that's me, financial disclosures. I am the owner and founder of Grandbois Therapy and Consulting, LLC, and co-founder of SLP Nerdcast. My non-financial disclosures, I'm a member of ASHA SIG 12, and I serve on the AAC Advisory Group for Massachusetts Advocates for Children. I'm also a member of the Berkshire Association for Behavior Analysis and Therapy. Okay, so we have some interview questions for you about what happens when things don't go well.
Right.
But before we get into that, I wonder if you could tell us a little bit about IDEA, maybe some fundamental components of the law in and of itself.
Yeah, of course. And before I do that, I just want to give my little legal disclosure that all the information that's being presented is for information purposes only. I'm, neither providing legal services, or our conversation is not creating a attorney-client relationship. If you have personal questions or concerns, always consult with your own lawyer. Okay. So now that all that is out of the way, we can.
It seems like a very important disclosure.
Yeah, it's a very lawyerly, disclosure. Anyone that's
it fits though. It fits.
It does. It totally fits.
It fits.
Yeah.
Okay. Carry on.
Okay. So, relevant laws for our discussion. So there's federal laws and state laws. The federal law is the Individuals with Disabilities Act, IDEA. There's a statute that you'll find at 20 USC section 1400. And then regulations, which generally provide just a little bit more detail than the statute, is 34 CFR part 300. In reality, what you're going to be doing is searching like child find special education law, but just to give you, more relevant, the actual numbers and things like that. The other law that we're going to be discussing is the federal law, section 504 of the Rehabilitation Act of 1973. And that is kind of where section 504 plans come from. That's 29 USC section 794. Again, most people just say 504, section 504, the Americans with Disabilities Act, things like that. So where in Massachusetts, Massachusetts has its own set of laws around special education. They can be a little bit different than the federal laws. So it's always really important for you to know kind of where you are in your jurisdiction, and what the differences could be. Like, for example, the federal law timelines allow for 60 days, 60 calendar days for an evaluation to take place. In Massachusetts, our law says 30 school working days from the date of receiving consent. So again, it's just important to know your state law as well. So from my perspective, there's 5 key sections of IDEA. The first section is the findings section and the purpose section. The next is definitions, state responsibility, evaluations and IEP, and then procedures and due process. So just to kind of frame the federal law. I think it's important to understand that the findings from the congressional testimony for when IDEA was founded talk about how important it is to ensure equality of opportunity, full participation, independent living, economic self-sufficiency for individuals with disabilities. They also talked about how it was important to have high expectations for our children, right? And to ensure their access to the general education curriculum, right? There's tons of case law for how IDEA came about, where basically if a student had a disability, they were basically told to go home, right? They were not educated way back, in the day. And the findings from congressional testimony basically, address that, to say, no, these are students that we just need to figure out how to help them, right? Like, how do you make their puzzle piece fit so that they too can sit in the class and, become whatever they want to become. So I just think it's a really important framework for how this needs to start.
I don't want to interrupt you because I know you have more to teach us. I just want to comment that so much of that is news to me. I mean, we
Right.
think as clinicians working in a school or as municipal employees, we are often there are components of that law that are really highlighted, mostly
Yes.
access to the curriculum, needs-based
Yes.
access to the curriculum. But I haven't heard a lot about economic independence. I haven't heard a lot about, what was the one that you said right before economic independence? There was another one.
Independent living.
Independent living. This is another one that I don't hear emphasized a lot within an educational setting. So I really appreciate you sort of giving us a scope of the breadth of what this law is.
It's broader than just, and I don't mean just in a way of minimizing it, but it is the purpose of the law, which is what we're going to talk about next, which is one of my favorite sections of the law, is just so much broader, right? Than, can Danielle sit next to her peer and listen to a math lesson, right? Like, it's just so much broader than that. And I realized that that was very simplistic. So in terms of the purposes of IDEA, and of course, no one's reading these things, right? Like, it's just the nerdy lawyer that is interested in it, right?
But because, that's why you're here telling us, because we're not going to read it.
No one's going to read this stuff, right? And so, but where did it come from and why, right, is super important. So one of the purposes of special education under IDEA is to ensure that all children with disabilities have a free, appropriate public education, FAPE, right? Everybody working in a public school has heard that, I'm sure, almost, maybe every meeting somebody comes in and says, my child's not getting a FAPE, whatever, right? So that's obviously in there. However, it goes on to say, designed to meet their unique needs and prepare them for further education, employment, and independent living. So again, how Congress and the congressional testimony went is they heard testimony, and then they took that and turned it into, okay, so this is really the purpose of our statute here, right? Like, one of the important sections, one of the important purposes. Another purpose is to ensure the rights of children with disabilities and their parents are protected. And that's why parents have these procedural safeguards that, in Massachusetts, we give out at every IEP meeting, and people joke about how, they've had so many, they can wallpaper their house with them and things like that. But there's a purpose, there's a reason why, we give those out. We have to ensure that educators and parents have the necessary tools to improve educational results. That's also one of the purposes of IDEA. And then to assess and ensure the effectiveness of efforts to educate children with disabilities. So very high level, right? But taking a huge step back, that's what all of you are doing in the school system, right, with all of your colleagues. And so again, I just feel like those things are so important to highlight. And frankly, when I'm looking at an IEP, when I'm talking to parents, I want to know, does this IEP help them either further education, employment, or independent living, right? I mean, that's the bigger picture of this down the line. So I used to have it as a sticker.
I'm sorry that I interrupted you. I love coming back to the bigger picture.
Yeah.
Again, because I think working in a school system, so many of us, we get very focused on our one job, right? So as a speech pathologist, my one job, we have many hats, but
Yes.
for the purposes of the IEP, your job, your quote unquote role is to provide services, to be in
Right.
compliance with the IEP. And that might mean direct speech services. It might mean training. It might mean indirect service, depending on what the IEP looks like.
Right.
But I love just the idea or reminder that their parents are a part of this team, that this
That's
law
right.
is overarching,
That's right.
that there are safeguards for all members of the
Yeah.
team. And that
Right. But you need
that
to be trained as well too, right? As new things come out, right? So how do you maybe get your administrators, if you need to, right, to help you bring somebody in to do training, right? Or allow you to do training for the paras, right, that are working with these students real time every day, right?
Yes.
Like, could you use the purpose of IDEA, one of the purposes of IDEA, to help that argument, to say, listen, like, we're all part of this bigger, wheel, right? Like, we each do our individual cog kind of section, right?
Right.
But like this, there's a bigger reason behind all of this.
Yes.
Right.
And I love, just to sort of pin it back to something you said earlier, I think, and we're going to get into this later, but I think many of us work in settings where we don't have an attorney at our fingertips. We don't have someone who has a deep understanding of the law. And often we are told by our administrators, who are not lawyers.
Right. Yeah.
We are told things that are maybe half truths, or we are told things that are myopic compared to the larger picture.
Yes.
So keep zooming out for us, keep going, because I think that this is it's a wonderful to set the stage before we sort of get into the minutia of what to do when these things don't go well.
Right. So another great section, and the next section that I think is really important for people to understand, is truly the definition section. Again, not a sexy section, right, of a law, right? Like, not something that people are like going to dive into, but it has so many important definitions that we work with every day, right? So one of them is a child with a disability, right? There's an actual definition for what that means. And there's a list of things. It means a child with an intellectual disability, hearing impairments, speech and language impairments, visual impairments, serious emotional disturbances, orthopedic impairments, autism, traumatic brain injury, or other health impairments, and specific learning disabilities. And who, by reason thereof, because of their disability, they need special education and related services. So what's important to understand, and sometimes more important maybe for families to understand, is that the mere fact that your child has a disability does not necessarily qualify them for special education services or related services under the special education laws, IDEA, or your state law, right? There's a combination that you have to kind of keep in mind. So you have a disability, and because of that disability, you require specialized instruction. You require a speech and language pathologist to help you with articulation, social pragmatics, any other of the social pieces, or comprehension, all the amazing things that you guys do. But it's not just, again, not saying just as a simplistic or anything like that, but you have to marry the two pieces. Again, the definition of free appropriate public education, or a FAPE, means special education related services that have been provided at public expense, under public supervision and direction, and without charge. It meets the standards of the state educational agency. It includes appropriate preschool, elementary, and secondary school education in the state. And then they're provided in conformity with an individualized educational program. So that's just the standard definition of FAPE, as it's called. Another definition that I think is important is called related services. And that's also where speech and language pathologists are included, specifically in the definition. it says transportation and such developmental, corrective, or other supportive services, including speech and language pathology, audiology services, interpreting services, psychological services, physical and occupational therapy services from the nurse, services that are designed to enable a child with a disability to receive a free, appropriate public education as described in the individualized education program of the child. So again, we're kind of tying definitions, back together for how do maybe speech and language pathologists provide services that are designed to enable the child to access their education.
And I think a lot of times, at least in my professional experience, those definitions can get sliced and diced a little bit. And the
100%.
semantics really, really matter. So going back to the way that the law is written, I think for those of us who are arguing with our administrators, or for those of us who are put in difficult positions, or maybe don't quite understand why it's contentious, going back to what the law says, I would assume is a very powerful thing, because again, if you've been told a half truth or something that's a little myopic compared to the grand scheme of things, that can be a very powerful tool.
I think it can be. And I think that, it's the black and white. It's kind of like what I say for you guys from a speech and language perspective is use your data, right? Like in a lot of ways, the black and white of the law is your data, right? And it can be as easy as saying, so this, I just happened to see this, or I looked it up, or I saw this on a Facebook group or whatnot, and it was posted. And so I was just curious, can you help me understand what that means? Because to me, that makes it sound like I should be doing X, Y, and Z, right? And maybe the help, can you help me understand, is a great way, I think, of kind of benching your ego at the door, and hopefully helping somebody else do the same thing, while opening lines of communication, right? I feel like in these situations, I'm constantly looking for ways where that's a possibility, because I think that's where a lot of good work can get done, or that's when a lot of good work can get done. And so I feel like I'm constantly looking for phrases and ways that are that can diffuse things, yet still prove the point.
I love that you said that. Checking your ego at the door is one of my favorite expressions. I feel like we need to now do a whole podcast on conflict resolution and conflict management, because it's so important.
It is.
And of course, we're talking about this in the context of a contentious IEP meeting, or when something has not gone well and there are big feelings in the room, and there are people who have, are bringing very different, strong beliefs and feelings to the table. So I think that that's such a wonderful suggestion. I'm so glad you said that.
And I think, listen, I guess I would say too, that in some cases, maybe the meeting's doesn't even start out feeling contentious, right? I think in any way, when I'm going into these meetings, and I'm thinking about, like, there's a child that I'm trying to see, how can I help them a little bit more? And so if you're a parent, that's always going to weigh a little heavier on your heart, right? So it's just going to make it a little bit more, like, the ante is upped a little bit, right? And so even if it's maybe not contentious, there's still this like feeling of, but something's not working and I need to figure it out, right? And so again, I mean, listen, I wish that phrase or phrases like it were written on every wall in every meeting room across the world, right? Because it gets a lot of us in trouble. And I think it's also important for everyone to understand that everyone is playing a role, and they have a role at that table. Right? The administrators have a role at that table, right? They're not just IEP members, not only IEP members per the law, because there has to be an administrator there or someone that's there to be able to commit resources for the district as a team member, right? But parents are there. They're required members of the IEP team. A general ed teacher is a required member. A special ed teacher someone who's providing services. These are all required members of the IEP team, and we all have egos, and we all have a reason for what we're trying to be there for, right? And I do talk to my families about that to kind of help everyone just realize, right? And like, this is our data that we're looking to use in order to show, you know, Danielle needs some additional assistance here, because what we're doing isn't working, and it's through no fault of anyone. It's just not, it's not working for her. So now what? Right. So I don't know. I felt like I went off on a bit of a tangent, but
it was an important one. It was a good one. Keep going.
Okay. So back to your point about just knowing kind of what definitions are and maybe having a little bit more information. So there's in the regulation at 34 CFR 300.34 related services, there's something specific to speech and language pathology services. And it says it includes identification of children with speech and language impairments, diagnosis and appraisal of specific speech and language impairments, referral for medical or other professional attention necessary for the rehabilitation of speech and language impairments, provision of speech and language services to prevent communication impairments, and counseling and guidance of parents, children, and teachers regarding speech and language impairments, which is a really important. No one talks about that.
Holy moly, I have a million things to say about that last one.
I bet.
I mean, training of communication partners,
yes,
indirect service delivery,
yes,
training of families, training
all
of
in the consult section of the grid.
Yes.
Yeah.
I feel like I want to ask you a million more questions now, but I'm going to hold myself until we get to the question section so that we can finish some of this.
Yeah, but I feel like that's a really important piece, right? So there's other definitions, supplementary aids and services, aids and services and supports that are provided in the regular education classes, right? So you might be providing services maybe outside of the class, but also thinking about, hey, what could help this student in the class, right? Especially communication devices, as you were just saying, or, other types of accommodations, things like that to help them participate in extracurricular and non-academic settings too. So we're kind of, the law also allows you and requires you to think about those things. So again, that can be helpful if you're recommending something and someone's pushing back to say, well, do we really need that? Do they really need that? If you feel strongly about it and you have your data to support that, then, yes, they do. And, oh, by the way, I happen to see that there's a section that says this is one of the things that we're required to think about. Okay, so evaluations is another area that I feel like, warrants discussion. There's all different pieces of the law that talk about this, what's required to be in the notice and description of the procedures. No single procedure is the sole criterion for you to use. So you can do observations, you can do informal, formal, right? It's not just, oh, we have to use the castle and that's all we can use, or whatever it happens to be. You are required to assess the child in all areas of suspected disability. So let's say you're doing an assessment and you're like, gosh, I'm hearing some things that maybe I wonder if there's something else going on. You may be told by your administrators, all you're going to do is this, right? Or you might feel like all I have time to do is this one assessment, right? Which is real, right? That's probably a big part of what's happening too, is that your caseloads are huge, right? And so, but I just would like to remind that the law does require for a child to be assessed in all areas of suspected disability. So if you feel like, even though parent didn't say on the form, oh, I'm worried about articulation, if you as the professional happen to notice that, and you wonder if that's holding them back from being able to participate like their peers, then let's do a subtest or something, right, to get more information about that and report that out.
I just want to emphasize again for everybody listening that assessment does not necessarily mean a standardized test.
Right.
You may be in a district where to prove eligibility, your state
Yes.
might mandate that you use a standardized test, but for clinical purposes, there are so many ways to collect
Right.
information. And often standardized tests don't give us the clinical information that we need. And we have
Right.
so many courses on assessment on our platform. If anybody wants to learn more about that, I will link those in the show notes as well.
Yeah, because I actually think, I know, again, even from a lawyer perspective, it's like, okay, so what's the standardized testing say? Because a lot of times that is what we're arguing, right, about in terms of, the student is not doing well in class, but then they did a standardized test with you and they came out all average, right? And so, but still something's not clicking for them. And, it's very encouraging when I sit in meetings and the related service providers, the speech and language pathologists will say, 1-to-1, the student did pretty well, but I can tell and I know that they are having problems from an observation that I did, or from talking to the teacher, or even in how they interacted with me, that even though they scored in the quote unquote average range, they are still someone that does need support and services. And you're doing that based on your clinical experience. Like, you're doing that based on your expertise. And that's exactly what we want to see, what the law requires, you to do. But I realize that we're working in a system as well, and that can be challenging. Okay, so let's talk about, sometimes I think it's helpful for people to understand that there is a section of the law that includes educational records, and what that means, and especially for related service providers who feel like they're producing a lot of data on a student, and is that data information that parents get or not? Obviously, there's specific definitions in the Family Educational Rights and Privacy Act, or FERPA. And actually the special education law includes the FERPA law in its incorporates it by reference in the definition. But I think educational record is records, files, documents, and other materials which contain information directly related to the student and are maintained by the educational agency or institution. So I just bring that up as a reminder, that's important for people to understand.
And I think one big takeaway for me when I hear that definition is paying a little bit of more close attention to my documentation. So, the data sheets that I'm writing on,
right,
the notes the progress notes, obviously there are some pieces of documentation that are obviously part of a legal record, but if you are scratching your data on a piece of scrap paper or keeping it in a notebook, by that definition, I could see some circumstances where that becomes part of their educational record. I have had families request my data sheets before.
That's right. I was going to say, it depends on the situation, and it depends on what's happening. I've had situations where that information is requested, it's redacted any other students' names that are included on the same page are redacted for that student from a privacy perspective. But yes, it's just an important piece. And if you have questions about that, I'm sure that your school district council can also provide, information and things like that about how you should keep that records, from your district's point of view. So in terms of the individual education programs or an IEP, there are several sections within the law, of course. We already talked about one of them, the required team members in an IEP team meeting, the parents, at least one regular education teacher, at least one special education teacher or provider, a school official who can commit resources, If you have test results, a professional required or qualified to interpret the test results, the student, if they're between the ages of 14 and 22, but they can also be excused. And if you have any outside agencies that are representing or responsible for transition services for the student, then they should also be invited to the IEP team meeting. You can be excused from an IEP team meeting. Parents can excuse you if you're not able to participate. The law does say that the consent has to be in writing, and then if your content area or related service is modified or discussed, then you should provide something in writing beforehand, so that that's kind of your contribution as the team member, and then the team will discuss that during the meeting. There are certain parts of the IEP I know that you all are well acquainted with, writing all the time. But parents and student concerns, which is one of, my most important, I feel like, parts of the IEP, student strengths, key evaluation results, of course, the present levels of educational, academic, functional performance. They're called different things throughout different states. IEPs are also sometimes called different things throughout the states as well. You're writing measurable annual goals, both academic and functional, designed to meet the child's needs that result from the child's disability, to enable them to make progress in the general education curriculum. I know we have some questions, I believe, on those things. Service delivery is another really important part of the IEP, about, when the student will get services, where they will get services, and again, services to parents as well as necessary. IEPs are in effect when they must be, once they're put into effect, they have to be made accessible to the special ed, the general ed, the related service provider, and any other provider who's responsible for their implementation. So hopefully your district or, has a program or something where you kind of get the IEP, and, there's some sort of tracker or something maybe, so that it shows that you reviewed it and had that information. Okay, and then Section 504 is the civil rights law that prohibits discrimination against individuals with disabilities. It's ensuring a child that has a disability has equal access to education. It requires that reasonable accommodations and modifications be made for the child with a qualifying disability. There are a list of qualifying disabilities in the law. 504 plans do not require public schools to provide an individualized educational program that meets a child's unique needs and provides the child with educational benefit. So that's a big difference. Not to say that Section 504 plans are not useful or helpful or appropriate or exactly what a student needs for them, but it's just one of the differences. Some of the other differences are that 504s are technically not required to be written plans, although, in every district that I've seen that they are. You aren't required to provide progress reports like you are for an IEP. There's no annual team meeting requirement in the law. There's no requirement for transition planning like there is on IEPs. But you can still get related services on a 504. It's just that those 504s generally, although I have seen some, so unfortunately, it is kind of district dependent, where they will write almost like a service delivery into the 504. Those are rare that I've seen anyway, but I have seen where that has happened.
Okay, now that we have the lay of the land, you've given us such a wonderful overview of the law, which I think so many of us don't truly understand because we're not attorneys, right?
Yeah.
We're clinicians. We're not supposed to know the law, but knowing
Right.
all the nooks and crannies, I think gives us a really good picture for the field that we're playing on. Pardon all of my analogies.
Yeah.
I want to lead this conversation with a question that our listener Kate asked, but also it's something that I've experienced. I have multiple colleagues who've experienced it. And the question is, what do we do as professionals when our clinical expertise is not in line with what our administrations expect us to do? And I'll give you an example. I have heard multiple times that students maybe they're given an AAC device, but they're just given an iPad with this one program because it's, quote, what we do here. I've heard that a lot. Or
Yeah.
we don't provide direct services on our IEP or indirect services on our IEP because, quote, that's not what we do. Right.
Yes.
So there's
Yeah.
this cookie cutter approach to service delivery, but we as clinicians, we may know better. We may
Right.
have a better understanding of how best to help our students, but we're in conflict with our own administrations over what we have the resources to do. How would you,
Right.
what do we do in those situations to be in compliance with the law?
So I think that, one, I think it's important to say what the student needs in the IEP team meeting. I do think that sometimes what happens is there's a hesitancy to say all the things that the student needs. But that's the place to do it, right? So when you're suggesting services to say this student needs an AAC device, the parent might be thinking, right, and you're going to train me on that, right? Or the teacher might be thinking, you're going to train me on that, right? The general ed teacher. And, if you don't say it in the meeting, then it will likely never be done. I mean, that's just how I operate a little bit, is like, if it's not said, if it's not written down, then it was never done. It wasn't ever said. Right. So say it in the meeting, make sure it's part of your service delivery recommendations, make sure it's part of your recommendations. So you're thinking about the recommendations to the family, to the other teachers, right? Your consults, the indirect support that you're going to provide for the student in the classroom, in specials, right? In electives or whatever it happens to be. In lunch, right? Like all of these areas, have to be thought about, right? So that's the B grid service. The A grid is the consult to parents, to other staff, and then the direct service is the C grid. So when you're thinking about your recommendations, if you think about all of those areas, then you're making that as part of the IEP team discussion, right? Which is where it should be done, maybe provide you a little bit of cover. And hopefully parents pick up on the fact that, okay, so these are things that should be in the IEP, right? If you're looking for more information about like what we were just talking about, right? Like, sometimes there's FAQs by your state that deal specifically with AAC devices, or people have asked questions before to other websites, like Wright's Law is a great, it's a very dense website. You can search it. There might be information there for you to find some articles on or things like that. They also have trainings, very accessible to non-lawyers. There's a website called Wright's Law, where Pete Wright, and who is a lawyer, and then does trainings that are very accessible to non-lawyers with his wife. And they talk about kind of the marriage, for pardon the pun, of between advocacy and the law, I think, which can be very helpful. They have a lot of books as well. They have a website that you can search. I don't spend a ton of time in the Facebook groups because sometimes I find that you're not getting the full facts. You might not be getting, the full set of circumstances, and you sometimes really need those in order to help you answer your question. If you're in Massachusetts, the Special Needs Advocacy Network provides trainings. The Federation for Children with Special Needs is another free. They do a ton of free trainings as well. They also have a Facebook presence. Each state, I believe, has some sort of parent clinic that you don't necessarily have to be a parent, right, to sign on to one of the webinars or things like that. So those are some just other areas where you can maybe learn some more information to help you advocate for your students, and also help you even feel more empowered, right? Similar to what we were talking about of like, bring in the definition from the law and just say, this seems like this would relate to me and what I'm doing. Can you help me with that?
I so appreciate all of these resources. And for anyone listening, we will link all of these resources in the show notes. I think you bring up such a great point that there is a lack of access to good quality information about the law, which is different than legal advice or having
Right.
a relationship with an attorney. The law feels like this big, scary thing that's cloaked in mystery that we just hope we're not screwing up somehow.
Right.
And I also just want to mention that you have resources available for clinicians and families as well, on your website, some low barrier to entry pieces of information and consultation. So we will, not to put you on the spot, but we will list your information in the show notes there as well, because I've learned so much from you. So I want to move on to some more questions about what we can do when things don't go well. So we've reviewed when we're in the hot seat and our clinical expertise is not aligned with what our administration says we can offer. I'm wondering about when the tables are turned. If we have recommended services, we feel confident that what we've recommended is in line with our clinical expertise, with best practice, with research. Let's, for the sake of argument, say we have our ducks in a row and we have hard data to support what we are recommending, but the parents refuse the IEP services and refuse to sign it, and there's contentions on the end of the family.
Right.
What are the legal procedures involved there, and what are some things that we need to keep in mind as the professionals sitting at this quote unquote hypothetical table?
Yeah. Again, not to continue to say the same thing, but I think what's important is that you as the speech and language pathologist for the student are providing and recommending the services that you believe will ensure that they can make progress in the general education classroom / curriculum, right? Again, that can be social emotional, that can be academic. IEPs are not just for academic reasons, right? So I think that's the most important thing to kind of keep in mind. And then from a parent's perspective, they have options. So they can accept the IEP and the services in full. They can partially reject the IEP, or they can reject fully the IEP. You have to tell, if you're going to partially reject, you have to be very specific. These are the areas that we're partially rejecting. You can reject for omission. So let's say, Kate, you're recommending 1 times 30 in the C-grid for Danielle. And I'm like, actually, I think that really what she needs is push-in services as well. You didn't recommend that. I'm partially rejecting the omission of the B-grid service, right? Or I'm rejecting the omission of a consult to parents to help learn the AAC device, right? Or whatever it happens to be. So you can also reject the omission of goals, the omission of services, the omission of accommodations, things like that. So anything that you do not reject will be accepted, and the services will begin immediately, is what the law says. Then obviously, if you partially reject, if there's some services that you reject, those services will not start. If there's a service that was removed or reduced, you can then stay put that service from the prior accepted service / IEP.
That was going to be my next question about stay put, because that's a phrase that's used a lot that is sort of, I've heard it used different ways.
Yeah.
It's a little confusing. Can you talk a little bit about the stay put concept and how it's applied?
And it's different. The federal concept is different than the Massachusetts concept, which is even more, I think, confusing. So it can apply to individual services, to an IEP, or to a placement. And you are asserting as the parent the stay put rights for a specific, service or goal, or because you don't think that the goals were achieved, right? Then you would stay put and those goals would remain. Unfortunately, what happens is that the goals remain the same. You don't get to update those. So you're basically kind of working off of the same information. But at least the service is staying with your child during that period.
Okay.
And then that happens until the dispute. Yeah. And then it's until the dispute is, because that's basically right. You're disputing. No, Danielle doesn't need that service, says the teacher, the parent says yes. So you have a dispute. So until that dispute is mediated, and there's a couple ways that can be done. You can have a meeting and you can resolve it, another team meeting and resolve it. You can go to mediation, or you can, file for due process. And federally, it has to be through due process.
Okay. I wanted to skip ahead a question or two, just because it's related to what we're talking about when there is a disagreement over the proposed service delivery. Can a chairperson or team member or administrator change the services on a grid without the consent of the certified professional? So for example, if in your example, the SLP recommends 1 × 30 in the C grid, and there is some dissent from the family or some rejection, can a non-SLP chairperson, administrator change it without checking in with the SLP, either to like push in or pull out, or some other service delivery model?
So what I would say is that no, that should be a team decision. The service delivery that is being suggested should be discussed within the team meeting environment, because the parent is a member of the IEP team. Presumably the speech and language pathologist who made the recommendations, they know the student, right? They have some sort of understanding of, from a clinical perspective, the expertise perspective, plus what the student requires, that, one could argue the administration does not have. And so I think all of those things are really important to be taken into account. And so that's one of the reasons why I say it has to happen. It should be happening in a team meeting, not after, because you're denying the parent the right of meaningful participation, which is a procedural safeguard for them. That being said, I'm 100% sure that this happens, either in pre-meetings or post-meetings, right? And if it's happening post-meeting and we've already had a discussion at the meeting that the student's going to receive 2 × 30 or 2 × 15, whatever it happens to be, then I'm going to say, administrator, you're not even involved in this. You weren't even at the meeting. You can't make that call. So but I know 100% that that's happening, throughout the country. And I'm sure that there's a lot of pressure put on clinicians, related service providers, in this process. I get calls from friends of mine that are teachers that are like, listen, I'm wondering, I'm doing everything. I've done everything I can for the student in the general ed classroom, and they're still not getting it. They need more. I suggested a tutor, which is a word that they might use, right, for special education support. And, may or may not have been told, well, we don't really want to say that.
You're leading right into my next question too.
Oh, well,
keep going.
Yeah.
Keep going.
So, the conversation that we had was, how can I, because it's a delicate balance, right? I mean, you have to work still, right? You have bosses, obviously they have not checked their ego at the door. They did not listen to the podcast and got that information, but so what my advice was, one is you have to give all of the data that you have and say all the things that you were doing in the general education classroom, and say, and he's still not getting it, or it's still not enough, right? Because you have to go that far, right? It's one, there are compliance requirements, right? Like if you are not able to provide what the student needs and you do not feel they're making progress, then you do have an obligation under child find, which literally means, means what it says, find the students with disabilities and, evaluate them to see if they need services. Then that's what you need to do. Better if you have some data. But if you feel like you can't go so far as to say they need a special education teacher, because of your administrators or your situation, say that without saying it. Like we see all those memes, like, tell me you have kids without telling me you have kids, or whatever it is, or whatever bad example I'm trying to give, right? Like, well, what are some ways that you can say? Like I also said, like, give some examples, right? Like this was the student's math quiz. And this was it before, if you can, this was it before I sat with them, right? They got one problem done in 45 minutes and it was wrong. And they couldn't show their work correctly, couldn't even write it in a way that anybody could read. And this was after I sat with them for 2 days throughout, kind of the free periods during school.
So showing that customized intervention as the data, more of like sort of like
as
a
another
dynamic
example,
assessment. Yeah.
Right.
So, and this was going to bring me, my question was going to be around this needs versus benefits. Needs versus benefits from question. And one of the questions that Kate brought to the table, which I want to emphasize, is how do we answer questions when a family asks us an innocent meaning question, such as, do you know anyone I can send my child to for outside speech services?
Yeah.
Or do you have any additional resources for XYZ deficit? And we are at times paralyzed by these questions, because if we answer them, then it looks like it's services they are supposed to be getting. So how would you recommend we navigate some of this needs versus benefits language when it accidentally arrives on our professional doorsteps, so to speak?
Yeah, I guess one, I would say it's such a shame that, providers, teachers feel like this, like, you can feel like your heart racing, like when you get asked this question from a parent, because you want to say, these are the services, but you feel put in a between a rock and a hard place, which I can appreciate. So I guess what I would say is, you might have to say, although the services that we're providing Danielle in school are what she needs in order to access her education in school, I can see how outside of school, maybe you would want to get her, more repetition or extra support, or maybe look at these areas, right? So you might have to start by kind of doing a little bit of, especially if you are providing them service, this is something that we're doing and this is why we're doing it. And we're happy to work with that outside provider too, because there's only so many minutes in the school day. And we also want to make sure that the student is having some time, right, with their peers in their classroom, or whatever it happens to be. So I guess I feel like that could be one way, right? Like, call out the fact that, you are providing the services that you think are appropriate in the school setting. Sometimes there are things that aren't going to be worked on in the school setting, right? I feel like this happens all the time with OTs and PTs as well. And it's really challenging. And I'm sitting on the parent side of the table. I'm sitting on the attorney side of the table. It's really challenging to hear, somebody say, we're not providing your student services, maybe because they're not failing enough, right? Or something like that. And the law doesn't require a student to fail, right? But, and really it's, again, you have to bring it back to, are they making progress in the general education curriculum? And there's a lot of ways that progress is measured. In Massachusetts, we also have a concept of effective progress, and there's a definition relating to that. And there's some case law about that. But it's tricky. It's really tricky. I'm not sure that I answered that in a helpful way at all. And I can appreciate that it's a very tricky situation for clinicians.
Was muted. I'm sure that all of the answers are rooted in the specifics of a situation too, especially,
Yes.
depending on whether or not you have the backing of your district,
Yes.
depending on how the question is asked, what the skill is. There's a difference between getting additional supports for extra practice for articulation versus
Yes.
training for an AAC device that is the main way through which you get access to a curriculum. So I think
Yes.
I'm sure that questions like that are just difficult to answer across the board, depending on the specifics. I am so grateful for your time. I know that we do need to wrap up, and I just want to say thank you for spending the time with us, for answering some of these questions. To anyone who is listening, if you're anything like me, you probably have more questions because this is such a deep well and an intersection that we don't often talk about in our field, how we interact with the requirements of our jobs and our workplaces and how we interact with the requirements of the law. So we really appreciate your time in highlighting some of these things. If anyone does have additional questions, we will put Danielle's website in the show notes, as well as all of the additional resources that she mentioned. So go ahead and take a look, get in touch. There is more help out there for you if you need it. Thank you again so much, Danielle, for joining us.
Oh, thank you so much for having me.
It was wonderful. Thank you so much for being here.
You're welcome. Thanks for having me.
Thank you so much for joining us in today's episode. As always, you can use this episode for ASHA CEUs. You can also potentially use this episode for other credits depending on the regulations of your governing body. To determine if this episode will count towards professional development in your area of study, please check in with your governing bodies, or you can go to our website, www.slpnerdcast.com. All of the references and information listed throughout the course of the episode will be listed in the show notes. And as always, if you have any questions, please email us at info@slpnerdcast.com. Thank you so much for joining us, and we hope to welcome you back here again soon.